Right, good evening everyone. Hi, my name is Timothy and I'm the Deputy Editor of the Exeter Student Law Review. On behalf of the Law Review, I'd like to extend a warm welcome and thank you to everyone for coming down to our event tonight. The structure of our event tonight will go as such. We'll begin with a presentation from our panel of speakers, before we go into a moderated question and answer session, and finally some light refreshments where you can spend the night talking about constitutional law. No, I'm just kidding about that. Anyway, without further ado, our first speaker is Dr. Kubo Mačák. He's a senior lecturer in law at the University of Exeter. His research interests span general international law, international humanitarian law, and the law of cybersecurity. Dr. Mačák was also the law school's moving director and teaches, amongst many things, my favorite module of parliamentary sovereignty on the constitutional law module. He will be speaking today about the interplay between statute and the royal prerogative. Without further ado, Dr. Mačák.
Thank you, Timothy. Can you all hear me? Does this work? All right. So yeah, I should say thanks a lot, and thank you to all of you who have come here this evening to listen to a couple of speeches about Article 50 of the Treaty on European Union. Maybe before I start, I should let you in on a secret. So what Timothy didn't say in his very kind introduction is that he is my dissertation supervising, who is writing his dissertation on the position of Article 50 in the UK constitutional framework. So I have to say this is one of the most creative ways of doing research I have ever seen. So thank you very much for holding this event. Now, obviously, the elephant in the room when we talk about Article 50 is that we are in this situation of quite a considerable complexity because nobody thought before the Brexit referendum took place, and even more importantly, before Article 50 as such was drafted, nobody seriously thought that a country would want to leave the European Union and that the United Kingdom would decide in a referendum to leave the European Union, because a lot of the problems that we are facing now could have been addressed very clearly by drafting a better Article 50 that would be drafted more clearly and in a more workable way. And then in the EU Referendum Act 2015, one sentence that would be added on the process of how exactly this Article 50 would be triggered would have spared us the complexity, but also it would have prevented us from meeting tonight and having hopefully an interesting discussion. So that's the elephant in the room, and we should put it out of the way because now we are in this mess and we should try to find a way out of it. But again, as another preliminary point, don't think that this is the worst situation in which you can be. So yes, we have a situation of constitutional complexity when a geopolitical arrangement is being unraveled, and we are watching this in slow motion as it's happening. But the situation could be much worse. Think about the dissolution of Yugoslavia, which led to, of course, a war. Think about the situation related to my home country, the dissolution of Czechoslovakia, where there was a law, a constitutional law, which prescribed that for any such dissolution there needs to be a referendum taken, but the elites just ignored this provision, and so in that sense the dissolution was illegitimate. So yes, we are in a situation of complexity, but it could be much worse, and the fact that we are discussing this from the perspective of law is, I think, again, another piece of good news. So what is this, that's the topic, what is Article 50, what is it about? So I need to make two disclaimers. One is that the picture in the analysis will always be incomplete, because as one unnamed law professor said on Twitter, he is looking forward to his retirement when he will finally get the time to read everything that has been written on the topic of Brexit litigation. So there you go, we can never know everything, but we will do our best. And then secondly, my own personal disclaimer is that I'm going to look at this situation from the legal perspective, so putting on the legal lens. So my political view as to whether Brexit is or is not a good idea does not enter into it, and maybe, as Timothy said, we can have drinks and discuss it afterwards, but I'm looking strictly at the legal perspective. So, what do we know? We know that there have been two cases before the High Court of Justice of England and Wales, so the High Court in London, that's the Miller case, and the McCord case before the Northern Irish High Court. Now, the two cases have been joined before the UK Supreme Court, and they are due for a hearing which will start in just about 2 weeks from now, so on the 5th of December. Now, in some ways, it's interesting because these two cases came up with opposing answers, even though the latter of the two decisions, so the decision of the High Court in London, tried to reconcile the two positions, and that's one of the last paragraphs of the ruling. Now, let's go. I thought that I would start with the questions that you have on your poster so that they are addressed. So what is Article 50 as such? Article 50 is a provision in the Treaty on European Union which specifies the process of withdrawal from the European Union. And it stipulates that any member state may decide to withdraw from the European Union in accordance with its own constitutional arrangements. And so the question before us is what are our, in the sense UK's, constitutional arrangements which prescribe how this process may take place. And we don't know that, obviously, because we don't have a codified constitution which would prescribe the process for such situations. And as we have said, the EU Referendum Act did not prescribe this process. So, then to the specific questions, with respect, I think they are the easier ones, and then I'll get to the relationship between the statute and the prerogative, which I think is the crux of the matter. So I'll take them in a slightly different order. They are the questions on the poster. So you probably are all here because you have read the poster and you might have seen the questions on the poster. So I'll take them in a slightly different order. First of all, are the results of the referendum binding? So the answer is very easily and clearly no. They are not binding, and it was clear from the start that the referendum would be of advisory nature. There are precedents in which referenda in this country were prescribed in such a way in the prescribing statute that the government was bound by the result of the referendum, such as the referendum on the alternative vote in 2011. But we don't have language to that effect here, so it's advisory. Then secondly, you ask here, has Brexit been blocked by the judges? So I understand the sentiment that underlies this question because we all read various news sources, and I know that Sue will tackle this in more detail. So I'm not going to go to talk about the media, but the answer is simply no. Brexit has not been blocked by judges. First of all, simply because the case is subject to an appeal. The Miller case, which is the one that has been linked to blocking Brexit, is subject to an appeal before the UK Supreme Court. And then secondly, even if the UK Supreme Court decides in a way that will be materially identical with the High Court ruling, then all that means is that Parliament must give its consent before Article 50 is triggered. So it's not blocked because if Parliament gives its consent, Brexit process may proceed as it otherwise would have. And then your final question here is, can Parliament now block Brexit? Well, the answer is yes, but again, this is the question is slightly misleading because it asks, can Parliament now block Brexit, as if something has changed. Parliament could always have stopped Brexit because of the doctrine of parliamentary sovereignty. And so at least until such time as Article 50 is triggered, when perhaps the situation will change, and that's something that Aurel will look into, so again, I'm not going to go into detail on that, at least until such time, Parliament is supreme in this country and may decide to reverse this process. All right, but so if those are the easy ones, then what is the difficult question? And I would suggest that the difficult question, and perhaps the key one in the judgment, and the key one that the UK Supreme Court will be facing in December, is about the relationship between the statute and the prerogative powers. And so to understand why this is the key and the crucial question, we need to take a step back. So when courts are looking at this question, what is how far does the statute go and when the prerogative powers take over, they are looking essentially at the relationship between the government and Parliament. So at the two main branches of powers, and at the extent of their competencies. And so I would put it to you, because we have again read criticism about how this is undemocratic, that the judges are going against the result of the referendum. So I would put it to you that in a democracy, which is based on a rule of law, setting the boundaries between the branches of power is the essential role for judges, is the essential role for the courts. So then the next step is, what does the answer affect? So the answer to this question, what I think is the key question, what does it affect? And again, you need to keep in mind, it doesn't affect whether Brexit will happen. It affects how Brexit will happen. And so it affects the exact process which will need to be taken after the ruling comes out. Now, if the Supreme Court holds that it is government and government only which may decide by the exercise of its prerogative powers, then this will permit the process to be more expedient, and it will permit more maneuver, more space for maneuver for the government. So you can understand why government would want that. Now, on the other hand, if the Supreme Court holds equally as the High Court has, that some nature or some element of parliamentary authorization is needed, then if this authorization takes form of a bill that is proposed in Parliament by the government, then yes, government may propose the bill as such, but then the bill becomes fair game. In the sense it may be amended by the House of Commons and later by the House of Lords, and both of those chambers may also delay the progress of Brexit. So that's why it matters, and that's why the answer is so crucial. Now, how do we answer this question? So, when we look at the case law that delineates the relationship between the statutes and the prerogative powers, I would say there are two main principles which arise from the case law. The first one is that if we have rights that are established by statute, these rights may not be extinguished by government action under prerogative powers. So once again, if there are rights which are established by a statute, then government may not extinguish these rights by exercise of its prerogative powers. That's the first principle. Then the second principle that's equally well established in UK constitutional law is that the conduct of foreign relations as such is one of the prerogative powers of the government. The conduct of foreign relations is one of the prerogative powers which the government holds. So when we take these two abstract principles and we apply them to the case in hand, they translate into two observations. Number one, that rights which come from this body of EU law, that come from the treaties and from the various EU instruments, rights on that basis exist in UK constitutional and legal order by virtue of one statute, and that's the EC Act 1972. So that's a statute which under one reading may be seen to have established these rights. And we'll get to that in a moment as to what this statute has done. So that's the first principle. Then the second principle about the conduct of foreign relations, well, your Article 50 on the poster, yeah, Article 50 that we're talking about, and the decision to trigger this provision is a prime example of exercise of foreign relations, right? It's something that the government does on the international plane. So that falls under the prerogative power of the government. Now, how do we reconcile the two? And this is the crux, in my opinion, of the High Court decision earlier this month, so on the 3rd of November. It basically held that the prerogative must give way. So that the statute beats the prerogative. This principle is endorsed also as it applies to triggering of Article 50. And so for the High Court, triggering Article 50 would inevitably result at one point, or I will talk about at what point, will inevitably result at one point in the extinguishing of rights that arise on the basis of the EC Act 1972. And because these are statutory rights under the reading of the High Court, the government needs parliamentary authorization in order to proceed with triggering of Article 50. So the statute beats the prerogative, and that's the fundamental point on which the High Court based its ruling. Now, where are we now, before I finish my presentation? Basically, the UK Supreme Court has two options. It will either endorse the ruling of the High Court, or obviously it will overturn it and hold for the government. The government is the appellant in the present case. So, in part, this is a semantic issue, right? It's an issue of labeling. How do you label these rights that arise on the basis of ECA 1972? But it's a labeling issue, it's a semantic issue that carries within itself a deeper legal meaning. So, what does that mean, a semantic issue? Well, the UK Supreme Court might decide to call these rights EU rights or international rights, thus removing them from the statute as such. Or it may treat them as domestic statutory rights. And it can actually find traces of both of those examples of terminology in the present ruling of the High Court. Equally, the Supreme Court may decide that the European Communities Act created these rights domestically, so the key word here is created these rights domestically, or it may hold that what this act does is merely to serve as a conduit, as a vehicle, or as the government puts it in a more complex phrase, that it sets up an ambulatory model for these rights. Right? So in other words, we have this dilemma between, does the EC Act 1972 create these rights as far as we're concerned? And if it creates these rights, then the High Court is right. And then parliamentary authorization is needed, because otherwise triggering Article 50, which is an exercise of prerogative powers, would go against these statutory rights, rights created by the statute. Or, and that's the submission of the government, the UK Supreme Court might decide that these rights are actually created somewhere else. Whether we call it the international level or the European Union level, they're created somewhere else. And they are merely, the EC Act serves merely as a vehicle or as a conduit for these rights that makes them domestically enforceable. And if the UK Supreme Court endorses this interpretation, then the decision will likely be overturned, because parliamentary authorization will not be needed for the prerogative power to be exercised in such a way that might go against these rights, because the EC Act does not establish them but merely serves as a conduit for these rights. So that is where we are at the moment, and that is one of the dilemmas, but I would say it's one of the key dilemmas for the UK Supreme Court. Now, having said that, everything changes if we can take Article 50 notification back. Everything changes. This whole analysis does not hold, and the result would be fundamentally different. But I'm going to leave that to Aurel. Thank you.
Thank you for that very insightful presentation. Our next speaker is Dr. Aurel Sari. He's a senior lecturer in law at the University of Exeter as well, and he specializes in public international law. He teaches on many modules at the university, including European Union law, and has published widely in leading academic journals and in other areas of law as well. Most recently, Dr. Sari has written about the revocability of an Article 50, of a notice under Article 50, which he will be speaking about tonight. Dr. Sari.
Thank you. Okay, can you all hear me? Is the mic working? As some of you know, I've got a cold and my voice tends to disappear at short notice. So I've prepared some slides. If I suddenly look like a fish and I can't speak and no voice is coming out of my mouth, then just look at the slides and we take it from there. So what I would like to talk about in the next sort of 40, 45 minutes, 10 minutes, is Article 50. So look a little bit more closely at what Article 50 actually says and how we're meant to interpret Article 50. Let's start off by looking at some fallacies. Earlier today, an article was published, really bad article, if you want to read a really bad article, look it up, which says that we can just leave, we don't need to trigger Article 50. All of that stuff, Treaty on European Union, forget about it. If the UK wants to get out, just get out, okay? Now obviously, complete and utter nonsense for two reasons. One is legal. The treaty is binding on the UK. The Treaty on European Union is binding on the UK. The UK cannot leave that treaty. It cannot withdraw from that treaty and withdraw from the European Union in any other way but through Article 50. That's your door for leaving the European Union. Now, of course, factually, the UK might say, right, we don't care. We don't care about the treaty. We will just withdraw. We will no longer play. Okay? That's a little bit like, you know, moving to a different house without really paying the last installment of the rent. You can do it, and if your landlord can't track you down, you can get away with it. Now, from a political point of view, this is a really, really bad idea, because we all know where the UK lives, okay? We can come around and we can demand the rent, but more importantly, the UK obviously wants to maintain some form of trading relationship with the other member states and with the European Union. that's not a very good start to your trading relationship if you still owe the rent. Okay? So politically, it's a very bad idea, but also legally, it's a non-starter. So we have to go through Article 50. We can just trigger Article 50, we don't have to wait for the Supreme Court judgment. Trigger Article 50 now. You have a lot of people marching up and down in London saying, trigger it now, come on Theresa, get on with the job. Why is that a bad idea? Well, as you already heard, under the first paragraph of Article 50, the decision to leave the EU must be taken in accordance with the state's own constitutional requirements. As we just heard, there is a big question as to what these constitutional requirements are. Were the UK to trigger Article 50 now, so the government sends off the notice to the European Council without parliamentary involvement, without having waited for the Supreme Court judgment, it's quite easy to see that the European Council is probably going to turn around and say, no, hang on a minute, we can't accept that notice because you haven't sorted out your own constitutional requirements. That notice is likely to be rejected, and rightly so. So again, we can't trigger now, we have to await the judgment. Third fallacy, Article 50 is all you need to know about withdrawing from the European Union. Why? Because it's European law, it's lex specialis. Forget about pesky international lawyers, people like me and Kubo. It's the European lawyers, it's all about Article 50. Well, that's a huge fallacy because Article 50, of course, deals with the procedure. But there are many, many questions which are not regulated by Article 50. Some of these questions may be regulated by other parts, other norms in the treaties, so other parts of European Union law. However, what you have to keep in mind is that the states, the member states, are creatures both of EU law, they are legal persons, legal entities with rights and duties under EU law, but also under international law. And that's a crucial difference between the institutions and the member states. The institutions cannot do anything, the institutions of the EU cannot do anything outside of the treaties. If they act, they have to point to something, a legal power, a legal basis in the treaties to take any action, but not the member states. The member states are sovereign. Okay? So they can potentially point to international law as long as rules of international law that they point to are compatible with the treaties. Okay? So Article 50 is not the final word on this. There is more to it. Final fallacy is Article 50 doesn't say anything about the revocability of the notice to leave the European Union, so therefore, it cannot be applied. There's one quite well-known blog post, widely read blog post, very influential post, which says, oh, you cannot look at Article 50 and then somehow imply terms which are conspicuously absent from the text. Really? Really? You cannot do that? Reasoning by necessary implication? How many of you have done EU law? Put your hands. Okay. Supremacy, direct effect, implied powers in external relations, human rights. All of these principles were found by the courts and were established by the courts by way of implication. Okay? Don't tell me that you cannot look at the treaty provision and not reason by way of implication. Of course you can. You can do it in any legal system, and especially in European Union law. So the fact that it doesn't say, Article 50 doesn't say anything about revocability is neither here nor there. You have to look at the text, okay? So, that guy is actually wrong. Why? The procedure for leaving is actually dead simple. If you look closely, you will find that there is very little procedure and there are very, very few, hardly any substantive conditions for leaving. Paragraph 1 tells any member state which would like to leave the European Union that it may do so. It may take a decision to leave in accordance with its own constitutional requirements. Who determines what the constitutional requirements of a state are? The state. It's not for the Union, it's for the state to do that. There are no other substantive requirements that the state must satisfy. Okay? It doesn't even have to explain its decision why it wants to leave. There are no real substantive requirements for leaving. Okay? So in other words, if the UK wants to leave, it leaves. It makes the decision. There's nothing. There are no other conditions attached to it. Very simple. This is where it gets a little bit more tricky. The second paragraph. What does the second paragraph say? Well, it introduces a little bit of procedure, a minimum of procedure. It tells the member state, if you want to leave, you have to notify the European Council of your intention. So basically, write a letter to the European Council. Okay, that's easy. Not too much procedure. Now, if you look at the subsequent sentences in paragraph 2, you will see that it does go into a little bit more detail, but all of these steps, for example, setting out the guidelines for how to negotiate the withdrawal agreement with the member state, consent of the European Parliament, all of these lovely things, they are steps which the treaty requires the Union to undertake. Okay? All of this doesn't really apply to the UK. It applies to the institutions of the EU. So the only thing in this paragraph that the UK has to do is send off that notice to the European Council. That's all. Third paragraph. Again, this is where it gets a little bit interesting. The treaties will cease to apply to the withdrawing member state once it has sent out its notice to leave in 3 possible ways. Okay, there are 3 trigger events. The notice doesn't terminate membership and doesn't terminate the applicability of the treaties immediately, but you have 3 ways in which this can happen. First of all, when the withdrawal agreement enters into force. Okay, the important point here is, it's not about concluding the agreement, it's not, hey, we reached an agreement, isn't this fantastic? No, no, it's about the entry into force of that agreement. That's a different thing. If you require, for example, in the UK, to get parliamentary consent to the agreement before you can sign it off, then you have to get that before the agreement can enter into force. Okay, so you've got to keep this in mind. So it's the entry into force of the agreement which counts. If the Union and the member state are unable to reach an agreement and that agreement does not enter into force within 2 years, at that point, automatically, after 2 years, the treaty will cease to apply. So there's an automatic 2-year period, it's a cut-off point. However, that 2-year period can be extended by the European Council if the European Council acts by unanimity with the agreement of the member state. Okay, what does this mean? Well, it means the following. If you go back, I'm not going to go back, but if you mentally go back to the previous slide, the obligation to negotiate and to conclude an agreement is imposed on the Union. It is not expressly imposed on the member state. Or you can say, it kind of implies that the member state is supposed to go along with negotiating, but there's definitely no obligation on the member state to conclude an agreement. Why? Because the entry into force of the agreement is not a precondition for exit. So that means the only thing that is a precondition for the UK to leave the European Union is the 2-year period. You put in your notice to leave, you wait 2 years, and you're out. So what that means is, if you look at the process, it is completely, totally unilateral. Okay? I'm obviously exaggerating somewhat, but it is massively unilateral. It really allows the member state concerned to decide on its own volition when and how it triggers, etc. And the only condition that affects its entry and the entry into force of that notification is the passage of those 2 years. Okay, can we change our mind? Can the UK, once it has given notice, revoke that notice? Can the UK change its mind? Why is this an important question? Well, as Kubo already explained, in the case of Miller, the applicants based their reasoning, their argument very much on the idea that once you give the notice under Article 50, it's irrevocable. So once the letter is sent off to the European Council, that's it. We're out, and because of that, the rights that UK citizens enjoy from the treaties and under the European Communities Act are gone. Okay? So whether or not that is actually true, in other words, whether or not you can or cannot revoke, is a pretty big thing for the applicants in Miller. So, by contrast, if it is reversible, if you can take it back, then basically people who would like the UK to remain a member have another 2 years. Okay? In which to argue and possibly create a consensus, get a new government, get a second referendum, whatever it might be. But you have another 2 years to engage in the political process because you can still abandon Brexit. Okay, so that's pretty important from a political point of view. But also what I would suggest is, of course, we're all focused on Brexit at the moment, quite understandably, but this clause, Article 50, might be relevant in the future. There might be Frexit, Grexit, and all sorts of other exits from the European Union. So what happens here and how we interpret and apply the provision will potentially have very significant implications for other member states and for the relationship between the member states and the European Union. Okay, so how do we resolve the question? How do we resolve the question whether or not a notice, once it has been given, can be revoked by the member state? Well, very simple. Okay? You have to interpret the text. And there are rules which govern the interpretation. One of the reasons why I wrote a big fat article on this subject is because I got a bit annoyed, all sorts of people telling us all sorts of different things about is it reversible, is it not, without actually applying the rules. This is law, there are certain rules, it's formal, you have to apply the formal rules of interpretation, and that will give you the outcome. So, what are these rules? I'm not going to go into the detail, but the key point is the Treaty on the European Union is a treaty, but at the same time it's also a constitutional instrument of the European Union. Because of that, you can apply the basic general principles of treaty interpretation that you find in the Vienna Convention on the Law of Treaties, so that's the VCLT abbreviation. However, you have to take into account the practice of the European Court of Justice, which tends to give more weight to the object and purpose of the European Union treaties. Okay, so this is the teleological approach that you might have heard about. You give greater effect to the object and purpose. So if we do that, you'll see the following. First of all, you have to look at the text. Well, we look at the text of Article 50 and it's blank. It doesn't tell us about anything about reversibility. Some people have argued, as I already suggested, that therefore it must be excluded. If it doesn't say anything about it, you can't reverse. Moreover, some have also suggested that if you accept reversibility, that would frustrate paragraph 3. Because paragraph 3 clearly implies that once you trigger Article 50, then one way or the other, you're out. As I just explained, not necessarily. You're not necessarily out. In particular, because the European Council and the member state concerned can extend that period indefinitely. So if you have a political agreement, nothing prevents them from doing so. If you have a political agreement within the European Council and with the UK, they can just say, you know what, this is a really bad idea, let's not go ahead with this, let's extend that period in the third paragraph indefinitely, and things will just bubble along. That is at least theoretically a possibility. The law does allow you to do that. Now, of course, you have to have the political consensus to do it, but the law certainly does allow you to do that. So it follows, in other words, that once you trigger Article 50, exit from the Union is not inevitable. Okay? There are other arguments as well, but I'm not going to go into that. Context. Okay? Context means you have to interpret Article 50 within the broader context of the other provisions. Okay? If you do that, what becomes very, very clear quickly is that the whole point of Article 50 is that you get out. Okay? The whole point is that you no longer want to participate in ever closer union and integration and all these sort of things, but you want to get out. That's the point of Article 50. It allows you to do that. It allows the state to assert its sovereignty because it can decide to get out based on its sovereign will. Now, if the state is sovereign enough, according to Article 50, to withdraw and to do so unilaterally and to decide about withdrawal completely unilaterally without any conditions and strings attached, why shouldn't the state be sovereign enough to change its mind? Okay? If it has the legal capacity to do one, it clearly must have the legal capacity to do the other. Object and purpose. To my mind, that's probably the strongest argument in favor of reversibility of the notice. What's the object and purpose of the Treaty on European Union? Essentially, ever closer union, ever closer integration. If you allow a member state to revoke its withdrawal notice, first of all, you give effect to that state's sovereignty. You give effect to its ability to change its mind. But also, you give effect to ever closer union. Because basically, you prevent the loss of membership. You prevent one of the 28 leaving the club. You keep the club together. By contrast, if you argue it's not permissible to revoke the notification, not only do you deny the member state's sovereign will, i.e. you go against the principle of sovereignty of consent and conferral, etc., but equally, you deny the object and purpose of the treaty. Because you say, once you have triggered Article 50, leaving is inevitable. But that's contrary to the object and purpose of ever closer union. Okay? Given that this is what the Court of Justice of the European Union looks at, the object and purpose, this is a pretty damn strong argument in favor of reversibility. Okay, very quickly, because I don't want to take up too much time and not go on for 40 minutes. If you look at other rules of international law, you will find that Article 68 of the Vienna Convention on the Law of Treaties specifically acknowledges that states may revoke a notice to withdraw from a treaty. Now this is where some people would say, oh yeah, but that's international law, why does this matter? Okay? It matters for two reasons. Number one, if this is customary international law, then the European Union, as an international organization, and its individual institutions, the Council, the Court, the Commission, are bound by it, provided it is compatible with the treaty. Secondly, if it is customary international law, then you also have to take it into account in the interpretation of Article 50. Okay? So basically all the points that I enumerated up till now are reinforced by Article 68 of the Vienna Convention on the Law of Treaties. Now the argument I make in the paper that I already referred to is precisely to say, look, it just so happens that Article 68 of the Vienna Convention is in fact custom, so it reinforces the arguments made before. Finally, some people have also suggested, in fact it was Lord Panic in his submissions before the High Court, he said, oh well, if you look at Article 50, clearly it was designed not to be revocable. Really? Really? Did you look at the negotiating history? Because if you do look at the negotiating history, it shows you that's nonsense. It clearly shows that what was intended with Article 50 was for it to be unilateral. And if it is unilateral, that means it all depends on the member state's sovereign will. They're sovereign enough to withdraw, they're sovereign enough to change their mind. That was the intention of the drafters. So again, it reinforces the conclusion. So I'll leave it there. If you want to know more, read the paper. And you've got the link up there. And basically it gives you the full argument, lots of footnotes and cases and other goodies. All right, thank you.
Thank you, Dr. Sari. Last but not most, definitely not least, our final speaker for the night is Dr. Suprit. She is an associate professor with the law school at the University of Exeter. She's lectured on and convened the constitutional and administrative law module as well. And she's also on the honorary board of the Exeter Student Law Review. She will be speaking about the impact of media coverage of the case and the wider constitutional implications of the role of the judiciary in determining the limits of Brexit.
Thank you very much. Can you hear me? Yeah. Thank you for inviting me to speak on my favourite subject at the moment. What I want to talk about, and you've heard a lot of the very legal issues, but what I want to talk about is some of the more unintended consequences that have happened as a result of the referendum and more recently the Article 50 litigation. I want to talk about the clash between parliamentary sovereignty and popular sovereignty in the form of the referendum. And I particularly want to talk about how that has led to a clash between law and politics. And this is all has been personified in the media and what's happened since the High Court judgment. And particularly, I don't know about you, but I was very excited when I woke up the day after the judgment had been made. Obviously had no sleep that night from reading through the case, and only to find that the next day the Daily Mail published on its front page pictures of the High Court judges and declared that they were enemies of the people, which seems to me quite an extreme view of the British High Court judiciary and not something that they'd probably ever been called before. So the High Court judgments certainly excited the Daily Mail, and they said that the judges who made the decision had defied popular will by determining that Article 50 decision could not be made by the government alone, that the case should go to Parliament. The Daily Mail, a very popular newspaper, personally denigrated the judges who made the decision and said that the 3 judges, one of them had founded a European law group, and European in capital letters, obviously a bad thing to have done. Another charged the taxpayers millions for advice, and the third was an openly gay ex-Olympic fencer. And this was a description of Sir Terence Efferton, the Master of the Rolls. J.K. Rowling actually tweeted after that had been in the Daily Mail, saying, well, if the worst that anyone can say about you is you're an openly gay ex-Olympic fencer, then life is sweet. The question before the court was actually about legal process. It wasn't a political question about whether or not we should leave the EU. And this seemed to be misunderstood by the popular media. I won't just concentrate on the Daily Mail, although I'm going to go back to it. The Daily Telegraph published pictures of the judges as well on its front page, and in order to really show how bad they were, it put a blue film over them, because I think that made them look more evil. The question, of course, before the court was whether the Prime Minister has the power to trigger Article 50, as you've heard already from Kubo. Whether she could do it on her own using royal prerogative, or whether or not this had to be a question for Parliament. But the Daily Mail and the other media seemed to be asserting that the judiciary had no place in making that sort of ruling that might go against the will of the people, what people had voted for in the referendum. And they couldn't make that decision even indirectly through using process. And so the underlying question to consider here is whether the judges should be making decisions on such highly politically charged topics. And it's particularly important in the UK because of our unwritten constitution and the balance between the different separation of powers, the different powers, and that is flexible, it is fluid, but it actually can shift and change over time. So I just wanted to explore that. And the question I wanted to look at was, does this anti-judge rhetoric actually damage our constitution? And so in order to do that, I want to look at how that might damage our constitution and look specifically at the rule of law and the separation of powers and how it might do that, and then pose you some questions to maybe think about as this case moves on to the Supreme Court and what the constitutional implications might be for the future. So, in terms of thinking about this question about anti-judicial rhetoric, the issue is really about judicial independence. If judges are independent and able to speak, then should they be able to be criticised in this way? Does criticism of judges undermine the administration of justice? And in this country we do have quite strong contempt of court rules which extend beyond the courtroom itself. Judicial independence is fundamental to the rule of law. It was originally recognised in the Bill of Rights 1689, which, as you all know, is fundamental to our constitution. Lord Bingham in the Belmarsh case said the function of independent judges are charged to interpret and apply the law is universally recognised as a cardinal feature of the modern democratic state, a cornerstone of the rule of law itself. It's the personification of objectivity and the embodiment of judicial standard. That's what we see when we see judicial independence, that judges, we don't see them as people in that sense, because what they represent is this standard of the law itself, and how the law itself sits above everything else in our constitution. Mark Elliott has called this a precondition of democracy, that if you don't have judicial independence as a fundamental of your rule of law, then you cannot have a democratic state. So what the media are doing by denigrating the judges is in some respects actually calling to question our democracy. So how does judicial independence fit into our constitutional arrangements? It tends to be governed by our old favourites, constitutional convention, except where it's written into statute. I'm going to come on to that in a minute. But by constitutional convention, the executive shouldn't criticise judges or comment on cases before the courts. So that's maybe something to watch out for as this case goes to the Supreme Court. Sometimes the executive find it impossible to be able to comply with that convention. By constitutional convention, judges do not defend themselves. Because they are embodying the rule of law, they will not speak up for themselves. And in fact, for that very reason, the duty, there's a duty on the Lord Chancellor to speak up for the judges, which is written into the Constitutional Reform Act 2005. And that is a very important statute in this regard, because that statute lays down the principle of both the rule of law in Section 1 and in Section 3 allows for judicial independence. And in that statute, Section 3(6) of the Constitutional Reform Act specifically lays down a duty on the Lord Chancellor to support judicial interests and uphold the administration of justice. So there's a duty written in to the Constitutional Reform Act for the Lord Chancellor, who is a member of the executive, to uphold the interests of the judiciary. And that there we see how the separation of powers is working, that the judges are separate, but within our constitution, the Lord Chancellor as a politician is the one who will speak up for the judges on their behalf to bridge that independent point. So when the media start criticising the judges, is there not a role, therefore, under what is now in statute, so it's no longer a convention as it was before 2005, not a role for the Lord Chancellor to speak up for the judges? And Dominic Greaves, who is a very outspoken, conservative, former Attorney General, said that judges are safeguarders of our unwritten constitution. So that role of judicial independence needs to be protected, because without that judicial independence, it threatens our constitutional arrangements. And he was even more outspoken. He said that the judgment itself, that even to say that you can change primary legislation by royal prerogative, so even to say that the Prime Minister could use the prerogative herself, is a constitutional monstrosity. So this is a former Attorney General actually criticising critics of the decision in the court. He said that in order to allow the prerogative to be used in this way, it would trash the Constitution. So very outspoken words on behalf of the media, but then the former Attorney General coming back and actually criticising those who have criticised the judges. The Lord Chancellor herself spoke out and said that judicial independence was important, judicial independence was important, but also the right of the press to freedom of speech was important. So not prioritising judicial independence over free speech on behalf of the media. And we can possibly question why a very political Lord Chancellor might make that statement. Another critic said the media were showing hostility to the rule of law itself, and that judges should not be seen as kowtowing to the executive, that it was very important that judges were seen to be independent, that is their democratic role. We could argue, and it has been said, that politically, if we look at this, that the whole argument for those who wanted to leave the EU was that we should take back control to our institutions. So if, as a result of this legislation going through the courts, the role of the judges is undermined in some way in our constitution, then that threatens our institutions. So we might want to ask what the implications are for that. But is the issue that judges were in fact stepping into the political arena here, and that they should have determined that this case was not justiciable, that this was a very political case, that even though they said it was procedural, that actually it goes outside of the role of the judges? And Lord Sumption, who is going to be one of the judges who is in the Supreme Court hearing the case the week after next, in a 2011 lecture very much said that parliamentary sovereignty was supreme, that there were areas that judges should not step into, and that there were specific questions that weren't issues for the judges. Lord Reid in the Belmarsh case said, the more purely political in a broad or narrow sense a question is, the more appropriate it will be for political resolution, and the less likely it is to be an appropriate matter for judicial decision. But he also said that the greater the legal content of an issue, the greater the potential role of the court, because under our constitution and subject to the sovereign power of Parliament, it's the function of the courts and not of political bodies to resolve legal questions. So in terms of this being a legal question, as you've heard from our two colleagues, it very specifically is. In the High Court themselves, the judges in the Miller case were very careful to state the boundaries and distinguish between law and policy. In the case, they said it's agreed on all sides that this is a justiciable question, so both sides, the government and the claimants, agreed that, which it is for the courts to decide. It deserves emphasis at the outset that a court in these proceedings is only dealing with a pure question of law. Nothing we say has any bearing on the question of the merits or demerits of a withdrawal by the UK from the EU, nor does it have any bearing on government policy, because government policy is not law. The policy to be applied by the executive government and the merits or demerits of withdrawal are matters of political judgment to be resolved through the political process. And then they went on to spell out the legal question, which I've already stated. They said we are not in any way concerned with the use that may be made of the Crown's prerogative power. If such a power can as a matter of law, be used in respect of Article 50, or what will follow if the Crown's prerogative powers cannot be so used. So they're not concerned with that, they're concerned with the procedure, and they spelt that out right at the beginning of the judgment. However, they didn't potentially do that clearly enough, because as I've already stated, that is not the point that we need to hit. Added to this, we can also say that although judges maybe don't make law, that the Human Rights Act has very much brought the judges into much more of a political arena. And Lord Neuberger, President of the Supreme Court, has argued in a recent speech that it's the Human Rights Act itself that forces the judges into making political decisions. So is it the fact that judges are now moving much more into a political arena that means that this sort of remit requires them to be much clearer about their role? The sort of statement that they've made in the High Court potentially will be reinforced again in the Supreme Court. So just one more point that I want to make. What about the Supreme Court and what's going to happen in the future? When this case reaches the Supreme Court, all of the 11 judges in the Supreme Court will hear the case. We currently only have 11 and not 12 because one has recently retired. This has never happened since the Law Lords first sat in the Committee of the House of Lords in 1876. So the first time we've ever had a whole panel of judges sitting to show the momentous constitutional nature of this case. Meanwhile, Nigel Farage has announced that he's going to be leading a group of 10,000 people to march on the Supreme Court. 100 people.
100,000.
100,000, sorry, yeah, 100,000. However, anyway, a lot of people to march on the Supreme Court, not when the decision is made, but on the 5th of December, a week on Monday, 2 weeks today, which is the day that the judges start hearing the case. We can only interpret from that the idea is to intimidate the judges in some way into making a decision, or to showing the strength of popular feeling, popular sovereignty against this idea of what the judges might be determining. The former Lord Chief Justice, Lord Judge, has said this would undermine the independence of the courts, and very much criticised this action. More recently, since hearing that Nigel Farage is going to be doing this, Lady Hale has also come under the spotlight, another judge who will be sitting in the Supreme Court. Talking in a recent speech in Singapore, she described the Supreme Court as the guardian of the Constitution, and went on to talk about the Brexit case, explaining what happened in the High Court. This led to a defence having to be made by the Supreme Court itself to say that she wasn't making any political statements, she wasn't prejudging the case, she was just explaining the law to law students. And Lord Neuberger has also been criticised for continuing to say he's going to sit in the case as President of the Supreme Court because his wife has recently been tweeting some anti-Brexit comments. So these, once again, have drawn criticism from the media and have drawn the judges much more into the spotlight, an area that potentially that they're not so comfortable in. I would suggest that following the Constitutional Reform Act and a much clearer role for the judges, that in fact their constitutional position is much more secure than perhaps it was before. And the Supreme Court itself, since 2009, by moving into its own building and being much more open to the media, has become, much more open to the public and issuing media reports, has also become more accountable to some extent in terms of the law, and we can only serve to try and build on that. I noted that the Supreme Court is mentioned in TripAdvisor as being something like the 500th best place to go in London. So once again, we can see that the Supreme Court itself has a presence that maybe is being respected in certain ways. So the questions I just wanted to finish on is, what is the role of the media? Should the Lord Chancellor have criticised more overtly some of the outspoken newspapers? Should she have taken further action? Is there a strength of feeling from you as law students that this is perhaps something that is going to the edges of contempt of court? Should the Supreme Court have agreed to hear this case, how can they more clearly spell out to the media and to the public that this is a legal procedural case, and how can this case be used to educate the public in that way? And how can judicial independence be protected into the future if judges are moving more into making political decisions and their speeches that they make, even potentially on areas that aren't contentious, are falling more into the interests of the popular media?